Thank you for joining us for this casual conversation. Today, we're talking to Colin Lachance, who is a Canadian legal information disruptor and legal information agitator. Agitator. Colin, welcome.
Thank you, Horace. I'm glad to be here talking with you. It's always a pleasure.
Tell us about Jurisage.
So Jurisage is a joint venture between Compass, the business that I've been running for a few years, and AltaML, which is a machine learning company from the province of Alberta in Canada. And AltaML had spent a year working with legal data that I had enabled access to through a nonprofit that I set up, strictly for the purpose of saying, hey, what would happen if more people, academics, law firms, professionals, had the ability to work with law as data just for experimental purposes? Because Compass is a legal publisher and owns data. So AltaML was very excited about what could be done with data, but they came to learn that without having internal market understanding, they were building cool capabilities, but not necessarily knowing how to plug it in a way that made sense. So primary example of a super cool capability that they built was a sentence level classifier of common law decisions, classifying each individual sentence as pertaining to facts, issues, law, analysis, or conclusions. So 2,000 documents were manually annotated in order to train this classifier. Performs at incredible quality results relative to the performance of the annotators. And not being as immersed in the legal market as those of us who come from that market, the feedback that they heard as they were building it was that it would make an amazing search tool. If you let me search a case law database by saying, I only want to search within the facts, or I only want to search within the law or the analysis, or I want to search facts that match something and law that matches this and issues that match that, it's incredibly powerful. So that's what they built. They showed it off. Lawyers loved it. But you ask them the question, how often would you use it? And the answer was once a month. Because the part of the conversation that was missing was, how do you carry out legal research, and why do you stick with something that you know is going to frustrate you? Now, we don't have to name who the primary legal research providers are, but the limitations of all legal research platforms are well known to their users. But there's so many other elements that cause people to start with that it didn't make sense for them to say, even though there's a super cool function that I'm really excited about the results, to change 99% of my behavior for that 1% of the time that I need this.
Yep.
So AltaML said, well, Compass, let's find a way to work together to develop a venture that creates legal tech products that make sense for the legal market, and it's well understood. So we spent a lot of time canvassing the market broadly, all parts, publishers, large law firms, small law firms, knowledge management experts, law librarians, partners, young associates, and so on, asking what are some of the problems you have in dealing with legal information and knowledge and so on. So we took all of what we heard, and then we came up internally with a large list of ideas, and we zeroed in on some projects that would allow us to extract and present knowledge at the right point at the right time. And as far as developing the company around it as a venture, came up with about 30 or 40 different names. And when somebody suggested Jurisage as a name, that struck immediately. So we said, yes, Juris for the philosophy of law, the science of jurisprudence and all that, and Sage for an intelligent assistant. So that's sort of how we came to be. And the product that we've decided to roll out initially, we call it My Junior, and it's focused on giving you information about the case that's referenced on the screen in front of you. So think of it this way. You've used whatever tool for whatever purpose to access case law. And as you're scrolling down the case law, you're reading it, you come to a paragraph and it references another case. And then another paragraph references another case. So even if your optimal tool has delivered you the 3 best cases that you should read, those 3 cases, especially if they've been published in recent years, probably cite 5 to 15 more cases.
Yep.
And so that's the point at which my junior is there to help. Because we're a publisher, we have access to case law data directly. So we analyze all the cases behind the scenes. As a browser extension, we look for the citation. And when somebody comes across the citation, they hover over it, and our little pop-up of intelligent insights appears. So it doesn't have to interfere with their workflow. We want to help them with that first decision. Should I read this cited case? Because if the case is cited for a particular proposition and you need to validate that it is correctly cited, you may need to open and read the case. But if we can find a way to give you that within 5 seconds, instead of you opening another tab, scrolling down to the document and finding it, we've helped you out. And if there's something more that you need, like who was the judge? Who are the other lawyers? What was the subject of this particular case? These are all elements that we're analyzing and developing in the background, including those facts, issues, law, analysis, and conclusions. So if you want to see a quick preview of the issues of the cited case, instead of making you search across a large database, we're taking your input, the smallest possible input of the citation, and saying back to you, oh, that case had these 3 issues. And here are the sentences in which they appeared.
Yeah.
And so that's what we're doing. And so because it's browser extension, it works wherever. So it will work on the major legal research suppliers. It'll work on the free legal research suppliers. It'll work on blogs. It'll work in Google Docs. If you're writing something and you write a citation, if we accurately captured it and recognize it, we can tell you something about it. So initially, we're building, we've built prototypes right now. That's the stage we're at, to prove to ourselves and to our potential users that yes, we can deliver on all of this.
Yep.
And we've built the prototypes just using Canadian data at the moment, but we have a US collection waiting in the wings. So by the time we roll out the product, the US collection will allow this to work. So if you are on Google Scholar, for example, reading US case law, sure, Google can give you a link to the full text, but doesn't exist to give you any additional data about the case.
You still have to go and read it.
Exactly. So we'll be able to do that too. And we're building everything in the back end as a large knowledge graph that will allow us to extend our understanding of the material and then deliver just those points of interest that the market tells us it wants to see in quick pop-ups. So long answer to a short question about Jurisage.
Hey, I love that answer. I think it's amazing. And usually from that conversation, I would have taken it down to path of how did you design this? How did you do the journey mapping? Because that's one of the things I've been doing with my team internally, going, guys, slow down. Let's build something people will actually use. Let's map out what the journey is and then insert ourselves into the right points in time. Because there's no possible way we're going to change the behavior of all of our potential users to what is the idealized version of efficiency.
That's right.
So instead, they have their habits. Let's fit with their habits. That's where I would usually take it. But you said 2 things from that, which I really, really want to pick up on. And they're 2 general ideas. The first is knowledge graph. You are probably one of the very few people I know in the market who's actually using knowledge graph in a way that makes sense. And then there's the other idea you said that was really interesting to me was law as data and legal data and what you consider to be legal data. But let's start with knowledge graphs.
Sure.
Just let's scratch a little bit beneath that. How did you come up with your schema? Because that is the biggest challenge for any knowledge graph. What is a node? What is an edge?
Yeah.
And kind of love to hear what your thoughts are on that.
So I'll tell you what our thoughts are, and I'll open by saying it is built subject to a lot of change, because we want to do this in a way that can accommodate the structures that we begin with for our Canadian and American collections, so that we don't have a Canadian knowledge graph and an American knowledge graph. The nature of entities and the nature of relationships and other aspects are often different enough that they don't force fit very well into one. So we have a conceptual graph that for the Canadian one right now. And so as in a parallel activity to building our product that we're putting out in the retail market for sale, we will be building the appropriate integrated graph in the background. And so in terms of setting up the schema, we have a couple examples that we're taking note of right now. So we have our current current relational database of Canadian case content has had some connections with other knowledge graphs in the past. One being that we have because we have topics from our collection that goes back to a big portion of our collection was acquired from a print publisher who had been operating for decades in Canada and shut down, and we bought it, and so that gave us access to a topical taxonomy of cases. So across 150 topics and 150 subjects, 1,000 headings below that, and 48,000 subtopics below that. So through the exercise of saying, well, how would we extend this over? We're thinking about topics as how they fit. We're thinking about the relationships on how they fit. We're also heavily constrained by what we have versus what we have to derive. We have a lot of parallel projects in place, and that's why we haven't really committed to building the graph first and then the app second. They're happening, from the knowledge that what we've built and shown off right now doesn't take us in the wrong direction from the graph that we intend to build, but it helps highlight the things that we need to consider based on how people want to engage and access information. And so the feedback that we're getting is telling us, like a great example is sentences and paragraphs and other fragments of the decision, figuring out how these things fit in and their relationship. You can have a fragment of a decision that has a relationship with the judgment itself. It has a relationship with a citation network. It has a relationship with a point of law if that fragment is a representation of a rule. It has other relationships. So we're starting from the perspective of saying, let's take the simplest version that we have, throw it into Neo4j, and then see what doesn't feel right. And that's one side of it. The other side that we're approaching it from is we're sitting down and saying, let's look at every possible property, relationship, like element, component, and that we can possibly think of, the nodes and the edges, before classifying them, and see if where we drive ourselves into a corner, where new ideas open up, and so on. So, and then finally, the last thing that we're taking into account are things like the Sally taxonomy. We really want to make sure that we're not building something that exists only in our own world, because it's not a proper knowledge graph if it can't accommodate connections with
the rest of knowledge.
With other systems. So the and I mean, we have the benefit that the fellow who's our chief data scientist, he's done extensive work in this area too, both in his postdoctoral research as well as just like lots of reading and consideration of it. So he's excited to sort of dig in and turn what we believe is the right thing to make it real. Because I want to go back to the product that we're putting out there. Our first product represents sort of the ethos of what Jurisage is trying to be. Like, we're trying to say, what is the smallest possible input that an informed user could give us, and what is the closest to correct and desirable output that we can give them. So by starting with, here's a citation, tell me a series of facts, we want to be sure that we can deliver those right little bits. And so as people tell us, well, now the input is a query, or now the input is something else, we want to know where it intersects with the graph,
Yep.
So we're not starting with search, or we're
Yep.
not starting
Yep.
at the document level. Every time we're trying to surface something, like a query, like a plain text query, is more likely to have a relationship with an issue statement,
Mm.
or even an analysis component. It's not going to jump directly to our extractions of what the law is or what the rule is, because you're skipping steps.
Yeah.
And so, yeah, we will be very open in discussing and sharing what our knowledge graph is when it's built, and it's being built.
Now, that leads very nicely to the question about legal data, because
Yes.
what do you consider to be legal data? And I have a view, I'm sure the rest of the market has a view, but what is legal data for you?
So for me, it's everything from the basic metadata about the document that you have, the text of the document itself, and borrowing a phrase from Damien Reel at Fastcase, and I don't know if he borrowed it from somebody else, the exhaust that's created by engagement and interactivity with legal information. And so that exhaust is I think one of the more interesting parts of legal data, and somewhere in the middle of that is the stuff that you purposefully extract. So we're working with a company called Private AI, and they focus on privacy enhancing AI software. And so with them, we wanted to see if we could train a model to differentiate, not just find names and find allocate the roles of the names, but differentiate between this person in this context of this judgment is most likely a witness and therefore deserving of a higher degree of privacy protection than this person who is a police officer testifying on behalf of the state.
Wow.
And so we're quite far along in that the model itself, if we roll up all the different categories of public participants and all the different categories of private participants, scoring really well at differentiating between those two. It's sort of breaking them down, but that's another element of legal data that we're creating, because it's incredible what's residing in these documents.
Yeah.
And so some of it is easier to pull out than others. And again, you can sort of imagine how this takes us into a world where we want to organize it in a graph instead of a bunch of joined SQL tables. Even though for a lot of basic stuff, that's more than adequate. But in our world, like the data really is everything from the documents to the content within the documents to the information about the documents. And we're working like almost presently exclusively with case law. But on the view that once we get this locked down to our satisfaction, then we have to move into statute law and a couple other things. We have to start figuring out how those things play with our system.
So, like, I think in your case it makes a lot of sense, because case law and statutes, they represent the real world, right? Case law talks about here's what happens when a set of laws apply to a set of facts. Legislation is here's what we want to happen when a set of laws apply to some future facts. And in those situations, I think the knowledge graph structure makes a great deal of sense, because you are linking together lots of different pools of information in a not necessarily orderly way that SQL databases do. And what you talk about in terms of legal data is really interesting, because it comes to an idea I've had, and I'm not sure how much truth there is to this, because I haven't fully rounded out the idea yet, that all of this information that exists inside of the documents, the case law, the contracts, and all that rest of the stuff, all of that's useful data, but actually the stuff we want, the stuff that's meaningful, you need to know what you're looking for before you go and scrape for that information. And it's illustrated by your point between public witnesses versus private witnesses, right? Like, as a transactional lawyer, I have no idea that there was even that distinction. I was like, they're just witnesses.
Well, and it goes to the question of like, why should I care? Like, what is the reason that I should care about this? And this is because of my greater and sort of larger and longstanding interest is in finding more ways for more people to experiment with this to create more solutions. And one way of achieving that is if we can create anonymized versions of the case law, that suitably anonymized versions of the case law, then the courts and privacy authorities have fewer. It's, again, we're talking about Canada and Commonwealth jurisdictions as opposed to the US, but fewer courts and privacy authorities will be concerned about the broad sharing of this as a data set for exploration if you've pulled out the identifiers of the individuals most vulnerable, whose details can be most at risk. Because doing sort of a blanket anonymization, like, yeah, we can find a name and turn it to name or pseudonymize it or do something like that, but courts are intended to be public. So, and particularly when it's the state versus the individual, you don't want to anonymize the lawyer for the crown or the state. You don't want to anonymize the judge. You don't want to anonymize the professional participants in the justice system. That sort of defeats the purpose of having an open court system. And so that's why we wanted to do it. And so we wanted to pursue that so we could share the data in bulk more. But connecting to what we're doing commercially, we don't want to create profiles of individuals. However, we do want to begin to have an understanding that, oh, that's interesting. Like cases that have this type of witness more frequently result in this type of result. There'll be new things that we can learn if we have that level of understanding. And so, yeah, we have multiple reasons for why we want to do it, and then then there's the how, and then there's the what next. Like what does it ultimately mean? But like in this case, our why was built entirely around finding a way to justify making courts more comfortable with sharing data more broadly. And so if we can say to a court, hey, you can put more stuff online if you anonymize it, and here's a model that we've created to help you do it, or if you already share your data, you want us to do it. Like, these are elements that we can assist in. We think there's a lot of potential, and it goes, like I said, entirely back to this idea of, look, if only the people who have access to complete data sets are in a position to create or come up with ideas, then we're really at a disadvantage for the amount of innovation and opportunity and benefits that we can see from like an agent technological advancement. Like, could you imagine if like the world said, well, I'm sorry, if Westlaw or Lexis didn't come up with it, nobody else can? Like that doesn't make sense at all. And so this is why I want to pursue that.
You have kind of laid out the perfect segue into the next topic, which is data analytics for legal data.
Right.
And it's almost like you planned this in advance. Did you plan this in advance? I can talk about the contract space because I think the contract space is what I'm familiar with, right?
Yeah.
And in the CLM space, or rather, let me rephrase. When it comes to contract data, most of the people in the legal tech circles are looking at the contract lifecycle management tools. And if you consider most of the contract lifecycle management tools, what they do is they're pulling out what I call commercially relevant data. Dates, dollars, percentages, periods of time, names of parties, etc. Really basic stuff when it comes to NLP. And they then create what is, I would guess, a nice, neat SQL database. And then that is the backbone of all of these systems.
Yes.
When you run analytics on that sort of data, what you are really doing is essentially a pretty simple frequency analysis or timeline analysis, right? You can't really do anything much more complex than that.
Right.
And yet you look at other industries and what they are doing with data analytics, what they're doing in terms of kind of the sophistication of being able to map out predictive data, being able to map out things that are really meaningful, that goes to solve complex questions, not just how many documents are we charging 5% interest on. I think legal is missing a massive potential here. And what you're doing, I think, is enabling that next step of being able to do real data analytics on information deeper than what you might call named entities in the NLP space.
I think there's some potential for that. Yes, I think I'll cap it at some potential, and it because of the volume of information, the bias inherent in a lot of historical collections, the gaps in what's available publicly. It really means that you have to take a large grain of salt with any output. However, if you incorporate all those elements, or keep all those elements in mind as you're pursuing analysis, yeah, it can be enormously powerful to have a sense of, is something trending in a particular way? What are the implications? What are the drivers? And you can go slightly farther than the statistical analysis when you have more elements that you can play with. When you can have the benefit of understanding, well, if I tune down the nature of the parties or the jurisdiction and tune up something else, does it lead me in a different direction? But there's still nowhere near enough actual data to do it in a way, sort of in a broad-based way, to say, and therefore the answer is X. I think that the companies that are pursuing in legal, therefore the answer is X, and here's my 75% confidence level on that.
Yep.
I think the ones that are doing it well, like Blue Jay Legal, approached it from the perspective not building the model first and then finding the predictor, is that they went in a very human way and read and cataloged all of the influences, and then tried to really understand, again, at a human level, what are the things that people care about. And so then you have pattern matching against, like, a guided interview against what people have cared about in order to make estimates about the influence of those elements. It doesn't really work to say, hey, we built a model in tax, and therefore it's going to work in labor, or it's going to work in family. And so if you approach it from that perspective of taking deep expertise and then breaking the decisions down and then building systems up and then applying AI to develop your analytics and predictive models, great. If you assume that just breaking down mechanically or algorithmically the details of content to find the patterns and then make predictions based on those patterns, I don't think it gets you anywhere unless you're doing it to help yourself understand where the problems lie, like where there's issues. Like there's this idea of saying, well, this has trended in a particular way, likely because of these reasons. And then you apply your professional judgment to say, do those reasons hold? Like, is that
does it smell? What? Yeah, the smell test.
Yeah, is that a valid reason? Or why would I argue something? I could argue something differently about that. And so I think the analytics are useful to serve as that sober second thought for the litigator or the attorney to say, here's what I think, based on my deep appreciation of the 5 times I've done this before, and then combine that with, and this model sort of pushes in that direction. That's interesting. How do I reconcile these things?
Yep.
But at the same time, where I think you improve upon that is take any given legal issue that you have a written judgment on. There's a really good chance that there'll be like an order of magnitude more applications that ever went to judgment on that, and an order of magnitude beyond that of issues, disputes out in the wild, or
that never even went to court, right?
Never even went to court. The first document was never filed. And so if you can if you can create a model for understanding case law and then bring it back into a law firm, and then use tools like yours to chunk out the content and figure out where to place it, you can extend these kinds of analytics models into internal data, I think, a little bit more effectively.
Yep.
And then say, well, never mind the 5 times a court has dealt with this issue. Tell me about the 50 times our firm has settled this issue.
Correct. And in a different direction, or
Yeah.
yeah. It's really interesting. You, as you're talking, two things came to mind. First is what you're talking about is effectively feature engineering
Yes.
in the machine learning space. And in the legal world, I think there's a greater push towards that now, with more legal engineers that are kind of a job that's come out of nowhere in the last 2 years. So I think we are heading in that direction of having domain experts create the right features.
Yeah.
But the second thing that came out that was really interesting was analytics. We can't talk about analytics in the abstract. We have to talk about it from the perspective of what's the use case? What are we solving? What do we need the analytics for? And what's really interesting when I talk to you is you have this perspective of case law, this really kind of like societal view of what laws are supposed to be doing, what case law is doing, what legislation is doing, etc. I think I spend too much time with transactional lawyers in big law because my perspective is, what is the market? What's used in negotiations? What's used in terms of arguments in litigation? What's used in terms of getting the lawyer to the position of winning, inverted commas,
Right.
winning? And so when I think about legal data and when I think about like legal data analytics, I'm very much thinking about this from the perspective of take everything that exists today and how do we shape it so that lawyers have the information to know the winning path. And my view on this is it goes way beyond the named entities, like knowing the dates, numbers, and figures. It doesn't solve that for you. What you want to know are the kind of more nuanced information around, okay, how is this drafted? How does this drafting that's used in 2020 differ from the drafting that's popular today? And what's the direction it's moving in? And therefore, where's the market going?
Right.
And I think that can be done without any feature engineering.
Yeah. I think so. I think you can find those. Again, the trends and where things are, how things are moving, how things are changing. I think volume plays into it as well too. In transactional legal practice, there's a really good chance that the core precedent for like a commercial lease in your database has been used a significant number of times, and you're aware of the departures from it. And so you don't need a whole lot of training to plot the trend of the departures.
The outliers, right?
Exactly. And the circumstances that they're related. Well, the departures were all because, Walmart was the client on the other side. Or
therefore they can flex their muscles and get whatever they want.
Yeah, exactly. Like some of those things can be exposed, I think, more directly with less human intervention. But it is pretty cool, like to realize like that we're getting close. Like we absolutely, like you and I absolutely need clients who understand that answers are in the system somewhere, and they understand that traditional search isn't a useful way of getting to those answers, and so it impedes their ability to get to the knowledge and impedes their ability to apply and reuse the knowledge, which is the point at which they get the benefit of it. Is that
so much of the system right now is still kind of the manual process of find the thing, read the thing, find the next thing, read the next thing, and then all that knowledge is maintained in one person's head. And if you're lucky, that person is going to write a memo at the end of that entire exercise and go, here are my findings. But 9 times out of 10, to be generous, that does not happen.
Yes. Yeah. And one of the things that we have built into our model is the ability to dig into that memo that person has written. And so when you see that, you hover over the highlight of the citation, if the firm wants, we'll be able to pipe back in and say, hey, we've indexed a memo in your data bank that includes a description of the holding of this particular case, and here it is.
Yeah, yeah.
Because we take the tools that we have for case law, apply to an internal memo bank or a brief bank for their appellate filings or something like that. And suddenly that information can be surfaced and presented again. Because again, the answer isn't necessarily in the trend of the public information. It's in the specific of the thing that you did last time and served you and your client well.
Right. And that's the tacit knowledge experts gather over time, which is so difficult to access, so difficult to tap into.